Next, we'll 7, but that's a long one, so I'm going to do the half-assed Article 13 now. These are bare minimum, as I was out of time. Small estates, $30,000 limit, only personal property, no real property. Voluntary administrator gets no fee. Filing fee is $1. If a deceased dies intestate and no person listed in 1303 is willing to administrate the estate or nobody exists, the CFO of the county gets the right to act as a voluntary administrator. A voluntary administrator qualifies and undertakes to settle the estate without the formality of court administration. If dies with a will, testate, the named executor has 30 days after will is filed to file affidavit required to act as voluntary administration. Otherwise, any adult entitled to petition for letters of administration with will annexed may file the required affidavit and act as voluntary administrator. Summary procedure, small estates, voluntary administrator. Here's notations about it. No waiting period after death is required. No bond is required. Person can file the affidavit located in the official forms along with certified copy of death certificate to become voluntary administrator. Clerk shall charge a fee of $1, file the affidavit, assign a number, mail each distributor or beneficiary a letter or postcard, notice of the proceeding. The giving of such notice is not jurisdictional, and no court order or other proceeding is necessary. The clerk shall give a short certificate, and it shall be evidence of a voluntary administrator's authority to act. The voluntary administrator shall deliver a certificate to each debtor, transfer agent, safe deposit company, bank, trust company, or whoever having control of any personal property of the decedent. Powers, what the voluntary administrator can do: sell personal property of decedent for cash, sue to recover decedent's personal property, sue to enforce a contract owned by decedent, have all rights and powers of a fiduciary of the estate until another fiduciary is appointed. Limits, what he cannot do: he cannot enforce a wrongful death or personal injury claim of the decedent. Duties, he shall open an estate bank account and deposit all money received. He shall sign checks drawn on the account. Without compensation, he shall pay the decedent's funeral expenses and debts out of the estate and distribute whatever necessary to the people named in the will. Account for all personal property received by him. Okay, so this next thing is about death of a creditor. I guess if you owe somebody money and they die and now you have the money and you want to pay them, this is like the rules for that. Debtor can pay spouse $30,000 upon death. Debtor can pay up to $15,000 not less than 30 days after death to spouse, adult offspring, father, mother, sister, brother, niece, nephew, or other creditor of the decedent upon request of one of them. Debtor can pay up to, I think that's supposed to be $5,000, to DSS when the debt is money payable on an account of a deposit with the debtor for the personal needs of the deceased creditor, i.e. like a nursing home or whatever medical services he needed, not less than 6 months after death. Not less than 6 months after death. The debtor can pay a debt of $5,000 or less to a distributee or someone that paid for the funeral, but there are conditions with this that must be shown by affidavit. $500, there's something about Social Security. $1,000, something about an infant and the public administrator. This article is remedial and shall be given liberal construction. If the sum is payable to a mental patient, it may be paid to the director. See Mental Hygiene Law 29.23. All right, next I'm going to go to, I think this one is 8 and 9. Again, many portions of this one are skipped. I tried to highlight like time rules and stuff that seemed like it might be easy to ask a question out of. Okay, so 801.1, no bond required if value of the assets is less than $30,000. Amount is, well, the answer would really be the amount defined for a small estate. So if they amend the amount for a small estate, this article doesn't have to also be amended. So just, if they ask this question, it's going to be no bond required if the value of the assets is less than blank, and the answer would be the amount defined for a small estate. Okay, it won't necessarily be $30,000. Bonds for guardians of infants not less than gross rents for 3 years or value of all personal property receivable by guardian. 801.2, unless court otherwise directs, the condition of the bond shall be that the fiduciary will faithfully discharge his trust, obey all lawful decrees and orders, and render a verified account when court requires. 801.4, obligees of bond. The bonds of fiduciary shall run to the people of the state for the security and benefit of those persons interested in the estate. 802.1, court may authorize law assistants or clerks to approve bonds. Approval of a bond must be endorsed thereon and filed with the court. Each surety on a bond shall file an acknowledged instrument stating his domiciliary address and designating the chief clerk or his successors as an agent for service. 803. Court may order the deposit of assets to reduce the amount of the bond in a case where the value of the estate is very high. 805.2. Court may require that amount of creditors' claims be ascertained by notice to creditors, which shall be published once a week for 4 consecutive weeks in such newspapers as court may select. Notice shall direct creditors to file written claims with the clerk on or before a specific date. Date shall be at least 30 days after the first day of publication. 809.1. I guess I skipped one. Shit. An action on a fiduciary's bond may be brought in either case. A. Person having a judgment or decree against the fiduciary which remains unsatisfied 10 days from the date of entry. Or by the fiduciary successor, or if no successor has been appointed, by any aggrieved person for the recovery of money not administered to him, or for an injury to the estate caused by his act or omission. 901. Temporary administration may be granted if in the best interests of the estate. This is when it could be granted. 1. Delay occurs in grant of letters or probate of will. 2. Person having an interest in property in the state has disappeared and is absent from his place of abode without being heard of after diligent inquiry. Such person shall be called an absentee. So what is an absentee? An absentee is a person having an interest in property in New York, they disappeared, and they're absent from their place of abode without being heard of after diligent inquiry. A person having interest is a prisoner of war or imprisoned in this country or a foreign country, whether legal or illegal, and cannot safeguard his property or care for his property in this state, and that person shall be called an internee. Oh my God, this one's long. 902, procedure for appointment of temporary administrator. 902, procedure for appointment of temporary administrator. 1. If a proceeding pending for probate of letters of administration, process shall issue to such persons and in such manner directed by the court. 2. If no proceeding is pending and the alleged delay is in a proceeding for letters of administration, process shall issue to persons who would be entitled to receive process on an application for such letters, or for probate of a will, process shall issue to the executor named in the last will filed in the court and the beneficiaries named in such will. 3. In the case of an absentee, process shall issue to the absentee and to his distributees as if he died on the date the petition was filed. Upon return of process, the court shall fix and determine the date when the absentee was last seen or heard of. In the case of an